Good evening. This is Crash Talk. I'm Mike Harber, your host. Another evening and another topic that will hopefully open your eyes to some of the things that go on in the world of insurance and auto claims. There's a myth about class action lawsuits, and I really want to pull the cover off of that because it is a myth. Now, not all class actions are created equal. And there's certainly some of those that, the cell phones or the siding on your house that the members of a class got $2.35 and the law firms made millions and millions of dollars. Well, you can't judge every book by the cover. And I wanted to ask a local class action attorney that has done good for us as consumers in this state. You've heard Steve before, and I have asked him to come back again to speak to this topic of class actions and the myth. So let me give my disclaimer. Mike Harber, my associates at Harber Appraisal or CrashTalk are not attorneys, and we're not giving you legal advice. But Steve is a practicing attorney in the state of Washington, and he may discuss topics that are legal matters, and he can do so because he is licensed as an attorney. So with that, let's go ahead and turn this over to Steve, and let's hear about class actions and how can it help you. So Steve, thanks again for joining us this evening for another show on Crash Talk, and I would like to really put aside the myth about class action lawsuits. I met an associate of yours years ago, Deborah Hayes, and Deborah Hayes and I sat down and she discussed with me about class actions and how it really provided the opportunity on smaller claims that it doesn't really allow people the ability to recover properly or fairly in certain situations because their claim isn't large enough. And so but maybe I should let you explain, because a lot of people, you start mentioning a class action and they say, oh yeah, I got $2.35 for the class action against Verizon, or I got $4.50 because of the bad siding on my house. And so there's been some real bad press, about class action lawsuits. So
some of those, first of all, as a general proposition, you're right. A class action is appropriate, and it's a great way to vindicate small claims that the consumer wouldn't be otherwise able to afford to hire an attorney to prosecute. John Doe versus Safeco. Safeco owns buildings. They have their name on a baseball stadium, that sort of thing. And here's the small consumer on the other side who's trying to challenge over a claim that might be worth $1,000. How economical is that going to be to pursue that claim? But and even on a smaller claim, let's say a telecommunications company charges a fee that's $2 over what it should be charging, something like that, right? That's just not that one consumer. That's going on hundreds, if not thousands, of instances. If it's a uniform course of conduct, and so it's not necessarily a lot to the consumer in some instances, but it's a huge deal for the company. And that's why, that's why you have to expect that they know about that and hope that they can get away with it.
Yeah. Well,
So,
my experience working with you and with the team of attorneys that you work with is that it hasn't been that way. I mean, at least what I'm aware of, and I don't. Are you at liberty to even kind of give a little bit of a range on the cases? Because I think I've been involved in at least 30 cases with your group, and the settlement for the members of the class, and the members of the class in most cases never were even told that they could make a claim for diminished value. Nobody told them. And so years go by, and all of a sudden, because of your efforts and your team's efforts, people get fairly compensated for something that they already paid for in the form of the insurance, because premiums were even, that's kind of come out, right? That when they set the premiums, they're setting the premiums based on all the potential areas that they're going to have to pay out on, and it included diminished value.
right. We've done a lot of work on diminished values, and we're doing work on total loss cases too, which are being underpaid. And so those involves the insurance claims pertaining to cars. And so by their nature, the underpayment or the non-payment is going to be higher than, for example, if you got if sales tax was improperly calculated on your cell phone bill. Okay.
Right.
The diminished value claims, for example, on average, are going to be somewhere north of $1,000. But
That's for so that would be for the members of the class.
well, yeah, and how we have resolved these in the past is that we have used we've used the value or the cost of the repair bill as kind of a proxy for determining how much diminished value would result from that. And it's all been done on a statistical method that my colleague Scott Neely is the expert on, and he could explain much better. But the basic idea is this: the higher the cost of the repair, the higher amount of diminished value. And the settlement formula that we've used in resolving these, which has been approved by a number of courts, takes that into account. So we've seen, we get information in terms of who gets paid what and that sort of thing. But we've seen settlement payments to class members that have ranged anywhere from a few $100s to several $1,000s. And again, that's the nature of the beast because it pertains to automobiles, which have a higher value, that sort of thing. But, we get phone calls from people when the notice of settlement comes out or when a check comes out and that sort of thing. And they say, gee, thank you. I didn't even know I was entitled to that.
Oh, serious? So you have people that call you?
Yeah. A lot of people will call initially because, these things take time to resolve, and some people they're not, I think I remember having that accident, that sort of thing. Some people just call to have more information, well, what's this all about? And in those instances, they will say, wow, I didn't even know, nobody told me I could recover that.
No.
And so that is, again, that is one of the beauties of a class action designed to retain or to obtain relief for everybody based upon a plaintiff or maybe 2 or 3 plaintiffs who are willing to come forward and stand up on behalf of consumers.
Yeah. Well, there's a certain criteria for it even to be able to move forward on a class action. I mean, there's all the stars have to be in alignment for it even to properly be able to move forward.
You have to show that there's what's called a numerosity requirement, which you have to show that there's a lot of people involved, so that individual claims would not be practical. Okay, there are cases that say that if you have over 40 people that are affected by the conduct, that presumably meets that. These claims, of course, have hundreds, if not thousands, of people that are affected. You have to show that what happened to them is based upon a common pattern, or that there are facts and issues of law that are common or predominate as far as all the members of the class. People would have different damages. Okay, in other words, they'd be owed different amounts, but that doesn't disqualify it. With the diminished value class actions, you have the same auto insurance policy that applies to everybody. That's in the underinsured motorist provisions. Okay, so it's the same language that applies to everybody. It's the same issue. In other words, failure or non-payment, and sometimes even underpayment of automobile diminished value. Those type of same, the same, of course, insurer. So, and then the same legal issues as far as, well, is diminished value available to insureds under the contract? Is diminished value available under Washington law? Those sort of things. And if you can show that the facts and the law are common and predominate throughout all the class members, that's another thing you have to be able to show. And then another hoop you have to show is that a class action would be a superior way to resolve this, as opposed to, well, if you had 1,000 class members, is it better to try to resolve the claims of 1,000 class members if they're a few $100s each, or should they go off and everybody try to sue in small claims court or something like that? And our argument, of course, that it always makes sense that this is a superior method of trying to resolve these, get everything heard, everything done, and resolved, so that everybody can benefit if possible. Now, if the judge does decide to certify it as a class, notice goes out to everybody who's affected by this, and they can read that notice, and it can tell them, if you want to participate, you don't have to do anything. You just wait till the results, whatever those might be, happen. Or if you want to present your own claim individually, you can check the box that says, I want to opt out of this and not participate, and I'll take my claim and pursue it on my own. So the notice that goes out by the court is a good protection as well. But yeah, the rule that governs certifications of cases as a class action talk about how the motion and should be presented to the judge, and the words are as soon as practicable. So the idea is to obtain enough information early on in the case through discovery so that you can present this to the court early on, and the judge can decide whether he or she believes that all the requirements of the rule are met. The one thing that is one misconception, I think, at that point in time, is that the judge doesn't decide who's going to win or lose in those types of motions at that time. The judge decides whether the criteria are met under the rule, that it makes the most sense to go forward as a class action. And as a general matter, Washington courts and case law decisions say if the court's going to err, the court should err on the side of in favor of class actions, because our case law is fairly favorable to consumers.
Well, your explanation was really good. Let me try it. The way I look at this, put it in a little simpler terms. My dad taught me when I was a kid, there's no free lunch. And if it sounds too good to be true, it probably is, right? So those were two things that I kind of grew up with, and yet I can't think of another opportunity for someone to be able to enter into a class action lawsuit as what's called the class representative. I can't think of anything else that violates my dad's two rules. That it's too good to be true, probably is, and that there's no free lunch. Because if you meet the qualifications to be able to act as that person that can step up as a class representative, first off, they got the best attorneys representing them probably in the country, not just in the Northwest, but there's no fees to them. They got the best representation, and it's all upside potential. There's no risk. I mean, it's one of the situations, and unless I'm missing something, but I like I said, I've been involved with you and with the group for a long time, and I've never seen a downside.
Well, people, people do have concerns about their decision. Do I want to step up to the plate and do this? And they are valid concerns. All right. They will ask, well, how much time is this going to take? And you have to explain, well, it will take a number of hours of your time, because through the discovery process, for example, you're going to be asked written questions. Those are called interrogatories. You're going to be asked to produce copies of whatever file materials you have about your claim. You'll have to participate in a deposition, because they have the right to ask, once you've answered the written questions and produced the documents, they have the right to take your deposition. We of course assist through all of this, but there are people, and for good reason, that would be very anxious about doing that might elect not to. And I get that. The other thing is you can anticipate that if a person comes forward as a plaintiff in a class action lawsuit, or I should say pretty much any lawsuit at this point in time, the defense is going to be investigating that person. They're going to try to look up that person on social media, those sort of things. And while everybody, it seems like on social media, everybody's life's out there about everything anyway, there's still some people that might not want to be subject to that scrutiny. People will be concerned as well. If I serve as a class representative, are my insurance rates going to go up, or are they going to get canceled? Yeah. We've never seen that happen. And I've been doing this now for 20 plus years. So we haven't seen that happen. But those are the types of questions we get, and they are perfectly valid questions. And some people are comfortable and they step up to the plate, and some people are not. And, I get that. Mm-hmm. But the willingness to come forward at that is wonderful, because really without people willing to come forward and doing that, we can't provide relief to the consumers.
Well, and the other very important point here, and I certainly try to make sure people understand this, is that you're not just doing this for yourself.
Right.
You're doing it for 100, 200, 1,000 other people, just like you had said earlier, never even knew. They didn't even know that they could make a claim. And, in the times that we're in right now, I think most consumers could use an extra few dollars. And And it's and the other thing that's even interesting about that right now is because I've heard this from several other people, how insurance companies are just benefiting from this pandemic because people aren't driving, they aren't wrecking their cars. And for the most part, I know there's been some relief and some premiums, but for the most part, it's not commensurate with the lack of claims.
Well, a couple of points. When you said it's not just them, they're going on to bat for everybody. You're absolutely right. And that's one of the things that we emphasize up front, is that one of their duties is that if we obtain a resolution or a settlement, of course, they're on board with us to make sure that everybody gets treated equally, and they're not putting their interests ahead of anybody. So it's all fair. The other thing about getting the check in the mail, I have literally had people call in after they've received the checks, thanking me, which is wonderful. But there have been a few times when I've had somebody say, I made my rent payment this month because of that. And that is, I still remember those phone calls. That's very, very gratifying.
Sure. Yeah. All right. Well, Steve, thank you very much. Hopefully you helped dismiss the myth that class actions are not any good and don't benefit the public. I'm glad you were able to share with us and give us your perspective on it.
Just one last thought on that. Okay. These are normally consumer related issues, and the state attorneys generals or that sort of thing, if there's something that's going on out there that is an unfair method of conducting business, or that something that's if there's a wrong going on out there, often the Attorney General's office is too busy, or they don't pay attention to those things, or that sort of thing. So it is a very useful tool of leveling that playing field in favor of consumers. Mm-hmm. And it's an important tool, and I think it's a very good check and balance between the consumer and between businesses.
Well, it's an efficient use of our court system.
Well, by definition, it is. If you meet all the criteria to get the case certified as a class action, you have cases that are too small to otherwise bring forward individually, and you've had a judge determine that this is a superior method than 100 or 10,000 lawsuits to resolve. It benefits I guess in theory, it benefits the business too, because you get these decisions, the issue gets decided once and for all. And of course, you don't win every case. So on the sides where the business win, they get it resolved with some finality as well.
I think your earned run average is pretty high, though.
We've done all right.
All right. Thank you very much, Steve.
All right, Mike. Thanks.
Steve, thank you very much. I hope everyone got a little better understanding of the importance of class action lawsuits, because they do help level the playing field. How else can a consumer with these small claims really get justice? How can they recover for their loss without having a vehicle like a class action to really help them? And you know what I tell people that I recognize could be a potential class representative for a class action suit is that this isn't about you. This is about everyone else that's affected by the same issues that you're affected with, they don't even know. The elderly couple, the single mom, the people that are struggling, and no one even told them that you have an additional element of your loss that's been overlooked. So this actually opens the door for all of those other people. And it's certainly, I think, a duty that we have as members of this society to help level that playing field. So if you've got questions about a potential class action, or how would it work in your situation, because not every particular claim is subject to a class action. There's only maybe 1 out of 200 that really qualify. But we can certainly answer those questions, and I know Steve would also. So with that, I want to just say good night. Thank you again for being here. Hope to see you same time, same place next week. This has been Crash Talk. Good night.